Okay, now I'm starting to record this. Hello everyone, this is Laws 12.061 Administrative Law, and we're doing tonight, which is Monday the 16th of December, the tutorial problems 11, 12, 13, 14 and 15, except of course, I didn't realise until the weekend when I looked at it, that problem 13 duplicates, at least from what I saw of the website version, problem 11, so it means that we'll do problems 11, 12, 14 and 15 because of that duplication. All right, now let's get underway. Just so we're all on the same page, problem 11 is the scenario involving Mr. Aidan Achilles, a Canberra grocer who gets assaulted. He might be the first person assaulted because they thought he was a politician, but we'll leave that one go there. Hang on, I've just got Stephen Colbrand coming on stream. Let me take his call. Hello, Stephen. Yeah, same thing I had last week, but this time I'm back in Chambers and I've got, I have no idea why the Logicam video thing won't work. I've tried swapping USBs on it and, you know, ports and all sorts of things. And for some reason it just won't take. Yeah, got the audio last time. There's no problem with that. That got uploaded. Got one student online already, so I mean, I'm happy to proceed with it. I started looking at it about half an hour ago, just thinking it would all be sweet, but it's not. Yeah, I'm not sure why. I mean, I went and bought a new Logicam thingy webcam for this. That's not if it's old technology, so not sure why. Okay, sure. Okay, sure. No, yeah, I've got them online. Yep, 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 yeah, I did, yep, yep, 3 it was. Yep, yep, sure. Okay, all right. Okay, thanks for your call. Bye-bye. Hi everyone, sorry I'm back. I've just spoken to Il Professore Colbrand. We don't know how to fix Zoom at the minute, so we'll just have to bat on regardless. I can obviously hear, is that Terry there, is it?
Yeah, mate.
Yeah, okay. I'm not sure who else has joined us, but anyway, it might just be a beautiful one-on-one session at the moment, and then others will chime in as they see, as they're able to. Okay. Did on the website, did it pop up that on the message of the week that the Zoom session was what it was? I mean, it did on my screen. I just wondered if that's how you got hold of it, or was it through one of the emails or anything?
Yeah, no, yeah, on the Moodle side.
Okay, all right. Okay, that's fine. Because Stephen said to also drop a link in there. So anyway, that's what I've done. All right. Okay, let's get cracking. All right. Sorry for the interruption, guys and girls. All right. We've got the situation involving Aidan Achilles, the Canberra grocer who gets assaulted. Now, as always, what's important is to notice the directive words in the question. And often they're buried in the fine print at the bottom of the problem. Notice that we are told or asked that Mr. Achilles is incensed at what he regards as the assessor's errors and is adamant that he wants to apply for judicial review. Now, without anything more, and for those joining us, we're just getting into problem 11. So the problem tells us exactly what we're meant to look at, and this is the question of judicial review. Now, we're also told, and again, this is very important in terms of the directives in the question, because you get directives in the exam paper too. Would he, being Mr. Achilles, be likely to succeed if he applied on the grounds of error of law, which is the first one. Secondly, exercising a discretion on the basis of wrong considerations and acting for an improper purpose. Now, given that we've got 3 grounds of judicial review flagged, if this was an exam question or something similar, then you would need to actually make sure that you address each of those 3 matters. And given that there are no weightings in terms of marks assigned to each of those 3 factors, you would assume, all things being equal, that the weighting for each is the same. So it means in an exam, you would also devote the same amount of time to answering that part of the question. And again, just as a question of exam techniques, it's no point trying to get, say, let's pretend it was worth 20 marks. No point trying to get 7 out of 20 for that segment if you spend 40 minutes doing it and then have no time to do the other parts. So as a question of exam technique, when you have a weighting for a particular part of a question, work out the amount of time you need to devote to that section. Don't spend a minute more, because the law of diminishing marginal returns says that every minute you spend too much on one part of a question means it's more likely you will get insufficient time for the other parts of your question, and you may in fact do a wonderful subpart and then fail overall on the question. So we don't want any of that. So it's just a question of technique. Don't overcommit your time on parts that won't get you any additional marks in the long run. Okay, that's probably enough of a homily from me. So coming back to the question, how we would resolve it. All right, we're told that he wants to apply for a judicial review. Now, normally that would be enough to say that we don't need to consider merits review. That is, whether we go to the AAT or in Queensland, QCAT, or any other equivalent body. But look, there's a couple of things that you would also think about, and even if you only said it in a sentence or two, if there is merits review available on the facts, then you would obviously indicate that as a pathway, particularly if the question is silent as to where his rights and remedies might lie. So if you get an open-ended, what are Mr. X or Ms. X rights or liabilities, then if you're not told specifically only to confine yourself to a particular area like judicial review, then what you do in fact need to do is to consider both merits review and judicial review. And the other thing to consider also, peoples, is that in some statutory schemes there are levels of internal review. So to give an example I often come back to, which is Centrelink, if you're not happy with the Centrelink decision, there's really 2 pathways. You go to a creature called an authorised review officer, and then he or she reviews the decision. If you're not happy with that, you can then take it to the Social Security Appeals Tribunal. Then if you're not happy with that, then you can take it upstairs to the Administrative Appeals Tribunal. So you always need to think about whether or not there is any internal review available. So sort of putting all those preliminary considerations aside, our job is to advise Mr. Achilles about judicial review, and we are particularly directed to wrong considerations, improper purpose and error of law. Okay, now this is obviously a tutorial problem question, but also in terms of your technique for the exam and for that matter real life. The first thing you always need to do is to figure out, what are you reviewing? That is, what decisions are you unhappy with? And that's part of a process we lawyers call characterisation. So we have to characterise or properly identify the questions, or in administrative law, the decisions that we are not happy with. And it's no different to other parts of the law degree you're studying. If you've done contract and torts, you'll know from doing those courses that when you're asked to advise a particular legal actor, you look at the things that have happened to them or the contracts they've entered into, or so you've always got to properly label or identify what area it is you're tackling. So in administrative law, we get, in theory, excited about governmental decisions. So the first thing is we have to identify the decisions. So if this was an exam question, the first thing I would do, apart from a very short introductory paragraph, which would be 1 or 2 sentences at most, and I'll just throw in a few techniques about exams as well. Don't do what a lot of students do when they're nervous. Don't rewrite the facts. Complete waste of time. You can assume the examiner's read the facts because he or she set the paper. So don't rehearse the facts. Complete waste of time. Just get straight into it. So in our question with problem 11, the first thing you would do, you'd write a subheading, what decisions are being reviewed? And then if we look at the facts, we would in fact identify 4 decisions. We might call the first one the financial loss decision. The second one is the counselling compensation decision. We have, which is the partial compensation problem. The third decision we have is the decision to refuse further funding. And we might call that the further counselling decision, if you like. And the fourth decision is call that the Hitachi decision, which is based on the fact that there's a question of somebody, Galton, steering our friend Mr. Achilles to a practitioner who only practices the Hitachi method. So we've got 4 decisions, and each of those may sort of raise some or different grounds of review depending on the facts. Okay, now if we look at the financial loss decision, what we've got is a question where we're told on the facts that the assessor, Mr. Galton, has rejected Achilles' claim that his earnings he's based his decision on Achilles' average weekly earnings, the AWE, on his tax returns, rather than stuff that, you know, his more recent earnings have been considerably high. So you can understand from a practical perspective why Achilles might want the more recent high average to be taken into account. Now, our facts don't in fact tell us one way or the other, and I think it's quite deliberate when the problem was set, as to whether or not the average weekly earnings, whether there's a legislative standard that applies to it. But let's assume, for example, that there was a maximum cap of, say, let's change our facts a bit. Galton, you're told Galton decides to award Achilles a total of $10,000 for financial losses, remembering that's the decision we're challenging. Now, if it turned out that the legislation, and we're not given details, said that he was the maximum ceiling or top rate was $12,000, then it could be an error of law if Galton, the assessor, doesn't actually consider whether or not to give Achilles the maximum of $12,000. So we're told on the facts he gets paid $10,000 to cover financial loss. So if the legislative ceiling has been maxed out in the decision, if I might put it that way, then there's no error of law. On the other hand, if the legislative ceiling was $12,000, just to change the facts a bit, then you might find there's an error of law because Galton, the assessor, hasn't, as a matter of jurisdiction, determined whether or not Achilles' higher earnings over the last few months might in fact have taken him over the $12,000 or up to or beyond the $12,000 limit. So again, just look at your facts and make sure you're clear as to what in this case, your maximum financial standard is. So that's the financial loss decision. On the facts, my view is there's no error of law committed. All right, let's go to the counselling compensation decision. Now, we're told on the facts that Dr. Prude is the guru in question, and that Galton only gives him, that is Achilles, $55 to cover 2 hours of counselling, whereas his counselling rate is $100 for $190 for a 50-minute session. And so really the gripe that Achilles has is that what he gets awarded by way of a counselling compensation decision is way under what he's actually incurred in terms of out of pocket. All right, so now again, we're not given specific legislation that tells us anything, but let's just look at the facts and maybe play with them a bit. And for example, if the legislation said something like, you know, a successful applicant is entitled to be reimbursed for their out-of-pocket expenses for counselling, then there would be an error of law on the part of Galton, the assessor, if he didn't award the full amount, because that would be by way of reimbursement. So again, you just got to look at your legislation or some other policy standard and see whether or not we go up to that limit or beyond. So at the moment, my conclusion on the second decision is that there is no demonstrable error of law. But if the facts were a little different, we had a different legislative standard, it could well be so. All right, let's move on and consider the Hitachi decision. Well, actually, that's number 4. I'll go back, and look at the further counselling decision. All right, now let's look at our facts again. And what we've got is Galton, the assessor, says, look, Sigmund Prude, or Freud, if you like, it's too expensive, he's no good, and he's reluctant to approve anyone who's not a Hitachi practitioner. So because he's got a concern about wasting taxpayer funds, which might be a legitimate consideration in the grand scheme of things. So what we've got is the question of whether or not that that ground can be impugned in any way. And if we have a look at the facts say 2 things. Prude is incompetent, and also the methods he uses are demonstrated to be inadequate. So what we have to do is see how does that fit into an established ground of judicial review. Well, if we have it that the counselling decision is influenced by Galton's assessment of Prude and by his belief that only the Hitachi method is satisfactory, Galton's decision would be flawed because of let's say the Hitachi method doesn't really work or something of that order. So now, don't forget, of course, that the courts in general are fairly deferential to decision makers, and it's really not going to be for a court to say, look, we prefer Hitachi method over some other method of counselling, say Sigmund Prude's methodology, whatever it might be. So the courts aren't going to prefer one or the other. They're going to say, look, does the decision maker have a right to take those considerations into account? So we're looking at the question of really wrong considerations. So can we conclude that Galton has actually taken wrong considerations into account? And don't forget, of course, it's a question of fact, and courts, generally speaking, don't revisit questions of fact in administrative decisions. So basically, we've probably got the situation where there's no demonstrable error of law when it comes to that further counselling decision. So if we jump back to the Hitachi decision and just recap for a moment, we've looked at 3 situations where it seems on the face of it that maybe there's no error of law. So maybe Mr. Achilles' desire to get judicial review might be on a hiding to nowhere. But let's have a look at the Hitachi decision and see whether that gives us any comfort. All right, now, we're told on the facts, and again, the facts control everything, both in real life and in problems such as this. We're told that Galton is married to one of the 3 practitioners of the Hitachi method who've been approved by the director of the department. And of course, obviously, our friend Achilles gets wind of this. The question is, does that have a relevant legal bearing when it comes to this particular problem? Now, basically, Galton is putting pressure on Achilles to use a Hitachi method counsellor. Now, in a sense, we're invited to infer that maybe one of the reasons for that is because Galton is married to a Hitachi practitioner, and the law of averages says that he might in fact benefit personally if Achilles actually uses Galton's wife. So the question then is, does, in administrative law terms, is that some kind of abuse of power, or does it involve, perhaps more accurately, the use of power for a purpose other than for which it was conferred? And I don't know if you've got the ADJRA Act handy or with you, but if you look at Section 5, And again, it's a bit like a checklist of things that we need to look into account. And if you look down at section 5 sub 1 and go to para E, that says the making of the decision was an improper exercise of the power conferred by the enactment in pursuance of which it was purported to be made. And then sub 2, 5 sub 2 elaborates that particular ground. And it ramifies it into several different branches, and one of which is taking an irrelevant consideration into account, or for that matter, the flip side, failing to take a relevant consideration into account, and perhaps relevantly for our purposes, look at 5 sub 2 para C, an exercise of a power for a purpose other than a purpose for which it was conferred. So let's go back to our facts. Can we say that Galton, in putting pressure on Achilles to use an Hitachi method counsellor only, can we say that this is an exercise of a power for a purpose other than for which it was conferred? And of course, we have the stark fact sitting in front of us that what we have is Galton's wife is an Hitachi practitioner. So it might be a slight leap of faith, but if we're asked, if we make the assumption, and you'd make it explicit if you were answering this, that Galton's purpose in promoting Hitachi was to divert business to his wife, then that clearly would be either an abuse of power or the use of power for a purpose other than that for which it was conferred. However, as in both exams and in real life, there might be another reason why somebody does something, and always think about that, because we don't always know why people do the things they do. There could be an alternative explanation, and let's pretend Galton actually genuinely believed that the Hitachi method is the only proper method. And notice what the facts say. He says to Aidan, and let's look at them, Sigmund is far too expensive, and anyway he's no good. It's clear from his report that he doesn't know what he's doing. If you have to have counselling, you must agree to counselling that works. I'm reluctant to approve anyone except a practitioner of the Hitachi method. It's the only method that works. So we have almost a standard of efficacy or something that works. So if in truth the motivation of Galton is to use a counselling or to approve a counselling method that actually works, then that may not necessarily be improper for him to have recommended a Hitachi practitioner. Notice that the facts don't say that Galton was heavily promoting his wife. Let's pretend Galton's wife had a different surname, so that she's not Mrs. Galton, so it's bleeding obvious. She might be Mrs. Smith. So if Mrs. Smith is in fact the one selected by our friend Achilles, then there may not necessarily be a problem. So it really comes down to the weighting you give to the two factors that can or propel the recommendation. So if we said that Galton's beliefs were persuasive, but his family interests tipped the balance, then the decision would be flawed under what we call a but-for test. That is, but for that familial interest, that decision wouldn't have been made. So therefore that would be wrong, and would also be an error of law. The key to it, people, is that we need to get some sense of how do we weigh this all up. And sometimes the facts deliberately aren't clear because you're being invited as students to consider, two possibilities. One is it is flawed for error of law, and secondly, the possibility may not be because Galton's indirect personal interests don't really do enough to tip everything over in favour of an adverse decision or a decision that can be attacked on legal grounds. So the question, I think, is deliberately vague in that it's inviting you to look at, both sides of the ledger. So when you look at it in total, I think the first three decisions I don't think we can overturn, but certainly there's grounds for, I think, impugning the decision by Galton to particularly promote or recommend the Hitachi method because his wife is a Hitachi practitioner. Now, let me perhaps go back to constitutional law and to take you back to a case you probably all want to forget, which is the bank nationalisation case. Now, don't forget, of course, and there's a reason for this story, the bank nationalisation case involved a situation where the Commonwealth government post-World War II wanted to nationalise the banks, hence the name of the case. Now, all the banks led a charge in the High Court to try and get the legislation overturned. And as it turned out, a couple of their sitting justices, it might have been Latham, might have been one of them, perhaps another judge, some of them were shareholders in banks. And so the question was, and it wouldn't have been the Commonwealth Bank because their share capital wasn't owned by anyone except by the Commonwealth at the time. So some of the private banks, might have been the National Commercial Bank of Australia or Commercial Corporation, whatever it was at the time, the predecessor to the NAB. I think some of the judges owned shares in that. Now, their shareholdings were so minuscule that nothing they did, the judges decided one way or the other, could have affected the value of their shareholdings or indeed what they got out of the case. So obviously a very minor situation or shareholding won't cause problems. But in this case, let's come back to Galton. And we're told that there are 3 practitioners only. So it's quite likely that, all things being equal, if Galton's wife is one of these 3 practitioners, then a decision that to recommend Hitachi over non-Hitachi practitioners could easily well be flawed because of that indirect material personal interest, because a third is a lot higher than, some minute fraction of 1% shareholding that might otherwise exist. So the moral to the story is you need to weigh up what it is that, in a practical sense, seems to influence the decision. And I think at the end of it all, that probably, given that we only have, 3 Hitachi practitioners, and statistically our friend Achilles might be picking Galton's wife, and so really that's an irrelevant consideration, or more likely, or perhaps more accurately, it involves, if Galton only approves Hitachi counselling, then because of his wife's interest, it's exercising a power for a purpose other than which it was conferred. So in my view, for what it's worth, I think Galton's decision is flawed, and it would be struck down on the basis of error of law. All right, now let's move on to question 12. And again, just to make sure we're all on the same page, we've got again, another variation to the infamous makepeace situation, which is really the subject of the very first tutorial problem. Sorry, my phone went off, given that's on silent. Okay, all right, coming back to makepeace. Now, we've got a situation where we're told the facts are slightly different. There's a new sub-regulation, and we've got the scenario involving MBA and golden years and Kelly University. So I hope that's the problem you're looking at, because that's what I am. And we've got again this problem of getting approval from the Attorney General seeking to import a psychotropic or some other drug that does naughty things to one's head, hallucinogenic drug. So what we've got is this situation. All right, so again, you always need to be very mindful of what the facts say, and in particular, what is the direction given to us that we are meant to be responding to. And basically, it's this, that we're asked to advise Kelly whether the Attorney General's decision to refuse permission to import this drug is invalid. And note also on the facts 2 other things. A certificate of the Attorney General has precluded AAT review, and we're also told that a Freedom of Information request yielded evidence of the role of this work experience student. And we're told also that the Attorney General's personal assistant is a person of utmost integrity and is willing to give evidence that the Attorney General only glanced at the letter. So that goes to the question of, if you want to extrapolate a bit, exactly how actively did the Attorney General consider the material the attorney was required to do or to look at in order to make a decision. So the question then is, the ultimate question for decision is the AG's decision invalid or not? So again, if we're going to do that, what we need to do is to find grounds for judicial review. And so a good starting point always is to treat Section 5 as a bit of a checklist. So when you're looking at these kinds of problems both in the exam and for that matter, that's a little importantly in the future for you guys, when you're either in a government department or acting against a government department and you're concerned about a decision, is use Section 5, the grounds in 5 sub 1, as amplified by sub 2, as a bit of a checklist in terms of working out what grounds for review do you want to particularly activate. So let's have a look at our facts, and one of the things we need to consider is whether or not the attorney has failed to take account of relevant considerations. And if we look at Section 5 sub 1, there's the improper exercise of power, and then just be aware that 5 sub 2 of the ADGRA amplifies what appears in 5 sub 1 para E. And so what we need to consider is whether or not the attorney has failed to take account of relevant considerations, and the particular one we should be taking notice of is 5 sub 1 para E together with 5 sub 2 para B for Barry or Belinda. So, all right. Now, when you have these things, you also need to go to the case law and see, does it give us any handy definitions or descriptions as to whatever the relevant ground is? And a good decision in this area is the Minister for Aboriginal Affairs in Pico Wallsend, and have a look at the decision of Justice Mason in particular, page 39 of that report. And basically, Justice Mason says this: a consideration is a relevant consideration if it's one that the decision maker is obliged or must take into account. So it's a question of obligation. And to work that out, you have to look at the statute and see what if anything does it direct the decision maker to do. And there are really two subsets here, and this is important at times. You sometimes have to take into account those things which the statute expressly requires you to take into account. And the next one is a bit more oblique or indirect, and sometimes you have to take into account matters which are determined by implication from the subject matter, scope and purpose of the Act. So it's a bit like, if I can use a private law analogy, the difference between express terms and implied terms in a contract. An express term is one that appears there, it's very easy to see. It might be in a written contract that you might be advising on. An implied term is different. It arises by implication of law, and we have in contract law that very well-known test from the BP refineries case, where you have to satisfy 5 elements as to whether or not a term is to be implied into a contract. So I'm using those private law analogies to try and get you to see the process of reasoning that you sometimes need to adopt in understanding public law concepts such as this. So coming back to what Pico Wallsend says is, sometimes the things you need to take into account as the decision maker are things that are determined by implication from the subject matter, scope and purpose of the Act. All right, now the other thing to keep in mind from Pico Wallsend too is that you have to take into account material that is actually or constructively before the decision maker. And to take something into account, according to Justice Gummo, in a case called Khan, Khan, and Minister for Immigration and Ethnic Affairs, which is an 11 December 1987 decision, in that case, Justice Gummo said that you have to give proper, genuine and realistic consideration of the merits of a case. So all those things flow back into how a decision maker ought to actually go about the business of making a decision. Now, this is where you need to step back and look at the beginning of the course and also at that Makepeace problem. Because at the beginning of Makepeace, you're actually given a fair bit of legislative black letter text that helps you, or is designed to help you understand this particular scenario. And we have there the Customs Prohibited Import Regulations 1956. And if you have a look at those regs, if you have them handy, then if you look at Regulation Subreg 2, just to remind you, the importation of goods to which this regulation applies is prohibited unless a permission in writing to import the goods has been granted by the Attorney General or by someone authorised by him, by the Attorney rather. And then Sub 2, A, says in deciding whether to grant a permission under Subreg 2, the Attorney or delegate, my words, is to have regard to certain matters, and there are 5 listed. So where this sits back, rather than get bogged down in the detail, remember that what Subreg 4, open bracket 2, AA, close bracket, is about is it's actually setting out a signpost of things that must be taken into account. And look at the words. The Attorney General is to have regard to. That's what we call their mandatory requirements or obligatory requirements. They're not optional. So coming back to our facts, let's look at it. We've got Kelly University's letter of 15 July raises several arguments to support its contention that permission should be granted. What we've got is the purpose of the research. And again, if we look sideways back at our prohibited customs regs, look at Reg 4, 22A sub A, the purpose for which the goods are to be imported. And there's also the question of their fitness to conduct the research for which they need the work, and that is have a look at subregs B and C from subreg 2AA. So what we've got is we've got facts that seem to suggest the attorney must look at certain matters. So coming back to our facts, the attorney was therefore required to consider those issues before granting or refusing permission. Now, while there can be times when a repository of power, such as the attorney, can be said to have given consideration to a matter if a subordinate has done so, then the question is that one of those matters? Now, coming back to our facts, what we also need to take into account is that we have a situation where we're told on the facts that the Attorney General's office read the application by Kelly University, and we're told that it was read by a work experience student who wrote a memo for the Attorney General saying that in her opinion the application was without merit. And we're told, again this is material, on 19 July, after reading the student's memo and glancing quickly through that letter of 15 July, the attorney wrote to the university saying he had decided to refuse permission. So what we've got then is we've got a situation where is it lawful or permissible for the attorney to have delegated to this work experience student the task of deciding the application? Now, you might remember before we've looked at the question of delegation through what's called the Carltona Doctrine, and that's C-A-R-L-T-O-N-A. Carltona Doctrine is a World War II case in England, and basically used a test of administrative necessity. The question is, again, does that help us in this case? And in my view, it doesn't. What we've told is the regulations, if you go back and look at them, actually provide for a system of delegation. There's no evidence that the attorney is actually properly delegated to the work experience student the question of deciding the application. So that kind of suggests that the application should be decided personally by the attorney and not simply flicked off to some young work experience student who might be all willing and earnest but not have the requisite experience to decide the matter properly. So this is a bit different to, say, the Pico-Wallsend case, where there can be reasons why a government official can use a delegate or subordinate to make a decision. Here we've got someone right at the bottom of the food chain, the student, who has made the decision, and it seems that the attorney has simply rubber-stamped it. Now, I referred earlier to the test from Khan and MIEA, where if you're going to take a matter into consideration, you have to give it proper, genuine, and realistic consideration. Now, we're told on the facts that what in fact happened is the attorney simply glanced at the letter. In other words, there's the suggestion being made whether or not the attorney properly took into account the things that Kelly University had written. And there's a good, reasonably powerful argument for saying that glancing at a letter is not enough. Now, there's always a question of evidence as to what the attorney has done. We're told on the facts that the attorney's PA is a highly principled person, and that person would give evidence to the effect that the attorney only glanced at the letter. One would expect that that evidence might be accepted by a court. And so what we would say is that really the attorney has failed to give proper consideration to those matters. So what we've got is a decision where the attorney has failed to take into account relevant considerations, and then from that springboard, which we probably say yes to, we then have to figure out, does that invalidate the decision? Now, in a sense, if the attorney would have made the same decision knowing the details or not, then that might suggest the decision stands. It's not invalid. However, what we've got though is the attorney doesn't really seem to have considered the material at all put forward by the university. So in my humble opinion, the failure to consider the matters put forward was material, and as a result of that, the Attorney General has made a legal error by virtue of having failed to take into account relevant considerations. So that means that therefore the decision does stand a good chance of being knocked out on judicial review. And really the particular remedy you would look at, and again, just to recap on remedies, again, just to run through them, just to get ourselves more familiar with them. There's mandamus, prohibition, injunction, they're the main ones, and the declaration. Remember, mandamus is to require a decision maker to do something. Prohibition is granted where a decision maker has exceeded their power. An injunction is to require somebody to either do something where it's mandatory, or to refrain from doing something, in which case it's known as a prohibitory injunction. And sometimes that can be pretty useful in administrative law, because if a decision is made beyond power or ultra vires, then you might want that decision blocked or stopped. You would think about an injunction. And certiorari is available where there is a jurisdictional error, such as a breach of natural justice or fraud, or a non-jurisdictional error of law on the face of the record. So, you've got a range of remedies. You always have to think about what is the one that is suitable for the facts at hand. And what we've got here is we probably want certiorari, which quashes a decision, because what we've got is the attorney not taking matters into account. So we want the decision quashed, and we want the attorney to reconsider it by taking into account those relevant considerations. Now, that's only part of the problem, because we also have to consider, did the attorney take into account irrelevant considerations? Okay, now irrelevant considerations are ones that the decision maker is bound not to take into account. You have to look at the language of the statute, if there is one, and the scope, purpose, and subject matter of the legislation. And again, what do our facts say? They don't really say a great deal on that particular point. Now, if we look at our facts, we're told that the DVC at Kelly University has what we might loosely call impaired ethics, and their treatment by their council are clearly not irrelevant considerations. And indeed, you could even say more powerfully that they are relevant considerations. So, you know, the question in this case is finally poised. We've got political considerations being taken into account by the attorney. And again, if we look at our facts, you're told three things in the reasons given by the attorney. Inadequate safeguards, number one. Number two was reservations about granting the permission to a university research centre whose treatment of academic fraud was inadequate. And then there's this community sentiment argument, the third ground. And so the question is are those things relevant considerations? So I think if you balance it all up, and looking also at the question of quality care, which seems to be some kind of federal government economic interest or stake, then what we've got is, if we look at the attorney's statement to Parliament, it doesn't rule out the possibility that quality care's interests influence his decision, but it certainly doesn't amount to a claim that his decision would have been the same even if he hadn't taken into account quality care. So at the end of it all, when you wrap up that particular second point, I think it's finely poised, but I would think that taking into account those competing government-controlled institutions amounts to an irrelevant consideration, and that's because they don't really go to achieving the purpose of the regulations in terms of controlling imports. So in other words, how well a government entity does or doesn't do in the marketplace doesn't actually have a bearing on how the decision should be exercised according to the legislation. So my view of it is that it's the decision would be attacked on the basis of taking into account irrelevant considerations. And again, the remedy would be certiorari, quashing a decision. Now, you also need to think in general terms, has the attorney exercised powers for an unauthorised purpose? Because the attorney can do that, that is, act for an unauthorised purpose, without taking into account an irrelevant consideration. So in other words, the two grounds aren't the same, and that's important to keep in mind. And basically, you would probably get round to looking at the case of Thompson and Randwick Municipal Council. That's a High Court decision at common law, really, that you have to look at the purpose for which the power is conferred. You look at the construction legislation, and in this case you would have a look at the fact that probably the attorney has acted for an unauthorised purpose insofar as the attorney based his decision on its contribution of quality care to the economic interests of the Commonwealth, rather than looking purely at the micro merits of the decision so far as it affects the university. So you have to look at the purpose for which powers are exercised, and particularly look at that Thompson and Randwick Municipal Council decision case. So at the end of it all, I would probably think that that would be an additional ground on which we might strike out or impugn that decision, and that is on the grounds of unauthorised purpose. Now, the other thing to always think about, although it doesn't come up all that often either in the case law or in real life, is the Wensbury unreasonable purpose test. And of course, that's restated in the ADJRA. And if you go back and look at section 5, just trying to find the relevant head again, it was just at my fingertips. If you look at section 5.1e, and then connect or dovetail with section 5 sub 2 para G, which is an exercise of power is so unreasonable that no reasonable person could have so exercised the power. Now that's a shorthand reference to Wednesbury unreasonableness, and basically what we've got is a couple of things that might suggest that's open on the facts. We've got the minister's somewhat cavalier attitude to the purpose of importation. In other words, he seems to have overly discounted the university's needs. And also, it might be arguable that the minister has acted unreasonably in preferring Quality Care's economic interests over and above those of Kelly University. So what I'm getting to is that there are a couple of factors which on the facts might point, not strongly, but perhaps somewhat in the direction of suggesting that the decision is bad at law. All right, now that's problem 12. As I said at the outset, and I'm not sure if everyone got it, only realised I didn't put the material on the website, but I just realised on the weekend when I was looking at the stuff that problem 13 duplicates problem 11. So that means we don't do 13 again because it's just been done. And we'll move on to... Yep.
Can I just ask a question there?
Yep.
Problem 13,
yep.
It's the same problem, but they're asking a different question. They're asking whether he'd succeeded on grounds of Wednesbury unreasonableness or lack of evidence.
Okay, hang on, let me look at it because maybe I missed it.
Very last line.
Yeah, hang on, give me a look at that. Oh, okay, all right, I stand corrected. Thank you for that. Shows you that I've disobeyed my own maxim, and that is look carefully at the question. Thank you for correcting me, Terry, that's good. All right, now, okay, we're looking at the same problem again, but only from the purpose of Wednesbury unreasonableness or lack of evidence. All right, now, again, this is a federal matter. I think we can infer it is. All right, let's have a look at the Wednesbury unreasonableness ground. We've just defined that actually in the last problem. And if you look at the section 5, is it the exercise of a power that is so unreasonable that no reasonable person could have so exercised the power? The question is, does Wednesbury unreasonableness give us any comfort when it comes to advising Aidan Achilles? Does anyone want to have a stab at that?
I'll go out on a limb and say no.
Okay, what's your reason for that?
Well, the unreasonableness factor, I guess. I mean, he genuinely believes that Hitachi method, even though he's married to a practitioner, he genuinely believes it's a valid method.
Yep.
And anyone else who was assessing that case could just as easily come to form a reasonable belief that it was an acceptable method. I mean, the fact that 3 practitioners have been approved by the director indicates to some extent that it's a method that's approved by the department. So
sure.
to be a long way to get to Wednesbury unreasonableness, I reckon.
Yeah, it sits there in the case law and obviously in the statute. In practice, it's quite hard to actually get over the threshold for it. So my view is, I don't think we get up on Wednesbury unreasonableness because we in fact have some evidence that suggests there's some proper basis for preferring Hitachi over Sigmund Prude's methods of counselling. So, for example, we have the stats, the statistics given there, and also the fact that the director is going to remove Prude, although of course we're told on the facts Galton is unaware of that. So, all right, I agree with you, Terry, that we don't get up under Wednesbury unreasonableness. All right, what about the lack of evidence ground, which is the second one?
Well, there is evidence, isn't there? The report there that shows the stats show that the other guy doesn't work. It doesn't matter that, I mean, Galton didn't know those stats at the time, but the evidence is there, and on review, arguably that evidence could be taken into consideration, or even if it was the decision was quashed to be remade, that evidence could then be there. So there is some evidence to back the fact up that Dr. Prude doesn't work and that the Hatashi method is a preferred method.
Yeah.
Galton just didn't know about it at the time.
Yeah. Yeah. In fact, what you're told he doesn't know is that Prude is about to be delisted. So, given that he wasn't aware of it, it might be a relevant consideration, but it's actually not one that has moved Galton's mind in making the decision or appeared on his intellectual horizon in that sense. So, I think the lack of evidence ground isn't made out. It's really for the same facts, same reasons that we don't get up under Wednesbury unreasonableness. There simply is some evidence. Legitimate minds might differ about it, but that's not a reason for actually kiboshing it. So,
because that evidence came out afterwards, after he made his decision.
Yes.
If you were to appeal, is that something you can take into account, that this is found out afterwards?
So that's often how things come up practically, Robin. What it generally means is that as this fact comes out later on, well, it means that it wasn't a consideration that, in this case, Galton took into account. So it probably doesn't really, practically speaking, have any weight. But it's a kind of thing that, had Galton known about it, he probably would have made the same decision, and it would have reinforced the decision that was in fact actually made. So just because of the way the facts shake out here, that particular ground can't be used retrospectively or, with hindsight to actually impugn Galton's decision.
Okay, so if you have something and you make a decision, and then you find out something afterwards, that's not a reason that you could appeal against that decision because they didn't know then something's come out afterwards.
Yeah, that's right. Okay. That doesn't work in all branches of law. Let me just use an example from contract law. You might have somebody who's breached a contract for reason A, but looking back at something later on, there might be two reasons that led someone to accept a repudiation of contract. You can use all reasons that exist. Different in administrative law. That contract law principle is a case called Shepherd and Feltex Textiles of Australia. But it's different in admin law because, coming back to our facts, the delisting proposal isn't in Galton's mind. So if it wasn't there, and it's not something he should have taken into account because we're not told it was, therefore it's not an operative factor. So therefore it doesn't go to impugning or invalidating the decision that was in fact made in this case.
So if there was something that you would expect. So say I make a decision at work and there's something that I should be expected to know and I make a decision, they could appeal on that because that was out there, I should be expected to know. But if something came later on, so say for example, I knock back a judgment on something.
Yes.
On damages, unliquidated damages.
Sure.
Because they asked for money first.
Yep.
I refuse judgment. They've come back at me with some case law beyond me.
Yep.
I've now got advice from, the higher people that I have to accept their judgment even though I don't necessarily agree with it.
Sure.
So that's what you're saying. So even though similar thing I've knocked back the first time, they've come back with some judge made a decision.
Yep.
They've come back with that. So that overrides anything that I make. So that's something that could get something overturned.
Yes, that's right. Yeah.
Does that make sense?
Yeah. No, I understand your example. Yep.
Yeah. Okay.
Okay. Sure. Okay, good. All right, let's, okay, I don't think there's anything else from my perspective on problem 13. I think that's the variations on the facts that I'm glad Terry steered me straight on have been covered well enough by what we've just discussed. All right, let's move on to problem 14 if we can. And again, this is this make-peace scenario sort of coming back to bite us on our collective derrieres yet once more. All right, again, look at our facts. We've got, and in reality, although I don't do it in an exam if I was writing as a student, when you get a whole big problem like this, what you would probably do in your perusal time in the exam is, because you get, what I think, 30 minutes or whatever it is, certainly on your wherever you're allowed to write in perusal time, you would actually probably get a very short summary of the key facts down so that you can, be really sure what it is you're advising about. So what we've got is, we've got first the refusal decision to import the work, the Night of a Thousand Shames. Then Makepeace, the applicant announces it's going to appeal to the AAT, and lo and behold, before it can appeal, the Attorney General issues a refusal certificate saying that the decision essentially shouldn't be reviewed on its merits by the AAT, and we're told two things about the certificate. First thing is, the certificate says that the book will impair the quality of Australia's relations with Caledonia, and secondly, their motive, the applicant's motive for importing the book, is to provoke conflict in Caledonia in the hope that it will achieve what we now call in the modern world regime change. I have a feeling parenthetically that those sort of considerations didn't really come to being when Australia went into Iraq, but that might be slightly controversial. I won't go there. All right, but same kind of idea. All right. Okay, so we're told also on the facts that the Commonwealth contends that it will argue that the AG was not obliged to afford procedural fairness to make peace before issuing the certificate. We're asked two things. Is there merit in the Commonwealth's argument? And secondly, assuming the Commonwealth had been under a duty to afford procedural fairness, would Makepeace's application for judicial review be likely to succeed? Okay. All right, so the whole, if you like, pigeonholing things, and as lawyers that's what we love to do because it helps us work out where we are in the legal universe. The first thing you need to do in any question like this is figure out what parts of the course is this question targeting. And basically, we've got a situation where the facts quite clearly say the Commonwealth contends that it will argue that the AG was not obliged to afford procedural fairness to Makepeace before issuing the blocking certificate. So really, if we need a label, and it helps, the label for this part of the question is, in fact, it's on procedural fairness. All right, so what we've got then is a question that is anchored in that part of the course, and so really we have to use the grounds for procedural fairness as a basis for either sustaining or attacking the action of the attorney in issuing the what I loosely call the blocking certificate. Okay, now if we're going to assess the merits of the Commonwealth's argument, in a sense, we're asked to advise on the pros and cons, or in other words, to argue both sides of the debate. So whenever you have a question, whether in this exam or other exams that you might be doing, if you're asked to assess the merits of somebody's position, you have to look at the arguments in favour and the arguments against. So given that we're looking at procedural fairness, first thing we would need to do when we're answering this question is to actually get a head around what is procedural fairness. That's a question of definition. So we have to look at and try and extract one from the authorities, the leading authorities. All right, so procedural fairness is where I would start is that famous decision in Kiowa and West from 1985. And basically, the High Court said in that case there's a common law duty to act fairly in the sense of according procedural fairness in the making of administrative decisions which affect rights, interests and legitimate expectations, subject only to the clear manifestation of a contrary intention, which usually come about through a statute. Okay, so that's Kiowa and West. So I might just pause there for a moment and just note that even back in that, in a very seminal or important admin law decision, in Kiowa's case, they basically say that procedural fairness is this duty of acting fairly, and it comes up all the time. In fact, I was earlier today asked to advise on a case where a federal magistrate had adjourned somebody's application in a court because the reason for the adjournment was to enable the respondent to an application to actually go away and get legal advice. And that person needed to get legal advice, and the court allowed the adjournment because it was subject to the court's duty to act fairly, that is, to give procedural fairness both to applicants and respondents in cases. So although that's a private law dimension, the same kind of thinking looms large here. Now, as well as Kiowa's case, have a look at re MIMA, ex parte LAM, LAM, 2003 decision. And basically, the Kiowa principle's been cemented further in Australian law, and there's now a lot of judicial support for the proposition that unless there's effective legislation to the contrary, the government is under a duty to act with procedural fairness in making executive decisions. That is, if the government makes decisions that affect the interests of people, there is a duty to accord procedural fairness. Okay. All right. Now, we then, keeping those things in mind, we then have to look at our facts and ask ourselves, is the government under a duty to accord procedural fairness to make peace in issuing the certificate? Okay, now, in order to answer that, we always have to go back to the start of the Makepeace situation, and we have to see whether there's anything in in Regulation 4, capital A, of the prohibited import regs. We've got a situation where the certificate can be given, and if you just need to anchor that in some kind of legal proposition, have a look at Regulation 4, capital A, sub 5. And it says the AG may certify in writing that in his or her opinion it is in the public interest that responsibility for a permission or refusal should reside solely with the AG and should not be reviewed by the AAT. So that's the mechanism under which this this certificate has been blocked or issued, resulting in a blocking decision. Okay, so the question then is there anything in Reg 4 capital A that actually suggests that procedural fairness does not need to be accorded to Makepeace? And just remember, it's not procedural fairness in the abstract, that is, somebody who's affected by a decision should have the right to have some input on it, which is, I think, a proposition we'd all subscribe to. It's actually quite a narrow application, and it's this: if the Attorney General issues the subreg 4A5 certificate, does that decision have to be exposed to the input of someone in the position of Makepeace? So this is where you have to, again, be very clear and precise in labelling your decision, making sure you understand what it is your decision is about. And and that's a really good question to always remind yourself: what decision am I unhappy with as an applicant? So it's that question of characterisation. So looking at Reg 4 capital A as a whole and glancing over the details of it, is there anything in that in that statutory provision that says that if the attorney is going to issue a non-review certificate, that Makepeace has a right to be heard about that decision. And my view is...
Where's 4 capital A?
Okay, it's right in the beginning in Makepeace. You know, the very first scenario?
Yeah, I'm looking at it.
Yeah, it's 4 capital A. The Customs Prohibited Import Regulations, 1956, Reg 4 capital A.
Oh, okay, right.
Yeah, and then if you look, it's a terrible piece of drafting. I mean, it's a dog's breakfast. But if you get through to sub 5, if you haven't fallen asleep by then you get to see that that's actually where the legislative basis for these non-review certificates comes from. I have to say, whenever I think I only ever encountered one when I was sitting on the AAT. Generally speaking, the attorney was happy to let most decisions go through. And I think I only ever did one or two prohibited import decisions when I sat on the AAT. So if a certificate gets issued, it blocks them, AAT can't review, and we're being asked here is, can that decision to issue the certificate be itself the subject of a requirement for procedural fairness? Now, in my humble opinion, that's actually a misnomer because no lawyer ever has a humble opinion, but we use the formal words because we want to be polite. Okay, so as long as you understand, I'm slightly tongue-in-cheek. And coming back to this, if you look at the whole of Reg 4 capital A, there really, in my opinion, isn't anything that actually indicates that a decision to issue a certificate is in fact subject of a duty to act with procedural fairness. Because the whole idea of issuing the certificate is to keep it out of reach of merits review. So, in my opinion, the issue of the certificate isn't itself subject to a duty to act with procedural fairness. Now, that seems kind of counterintuitive. I mean, we're dealing with an area of law that is promoting access to justice, that is admin law. We want decision makers like attorneys general to be subject to the law, the rule of law idea. We want, all people to be treated equally before the law, another cherished principle. But what you need to bear in mind is that all those wonderful ideals can always yield to a contrary intention in a particular case. And in my opinion, the issue of the certificate under sub Reg 5 can't really be challenged on the grounds of procedural fairness. So although that seems unfair, it comes back to this point, and that is the scheme or structure of Reg 4A as a whole seems to exclude procedural fairness. Now, the other thing to think about too is have a look at sub-reg 9. The Attorney General is to cause a copy of certificate to be laid before each House of Parliament within 15 sitting days. Now, where you've got a mechanism like this, and you see it in some pieces of legislation, what you've got is, if the attorney has to inform the Parliament about it, what it's suggesting is that there is political oversight. So in other words, Parliament could pass a censure motion on the attorney for actually issuing the certificate in the first place. So what it's suggesting is there's no procedural fairness to be accorded, but there is in fact political accountability. And there's at least one case law analogy that I can think of. There's a decision in Shergold and Tanner. Now, I think Shergold was the Secretary of the Attorney General's Department in the federal arena for some years, and there in Shergold's case, a decision to issue a conclusive certificate under the Freedom of Information Act. In that case, the High Court was reviewing that decision, which is in pari materia or analogous with what we've got here. And in that case, the High Court said this, and have a look at para 40 of that case. High Court said even if natural justice does apply, and they said the content of the requirement to provide natural justice to a person aggrieved by a decision may be very limited. So in other words, the High Court is flagging that when it comes to these conclusive certificates, that the opportunities for review on natural justice grounds may be really pretty narrow indeed. So my view is there's not a lot of mileage in challenging the decision to issue the certificate on natural justice grounds or procedural fairness grounds, certainly given the facts we have. All right, so the upshot then, if we're going to summarise the first question, is there merit in the Commonwealth's argument? You'd probably have to say on the facts that there is, because basically the legislation doesn't evince a sufficient intention to include or allow natural justice to apply in full measure, because you've got this requirement for a certificate. And I just think I think the negatives outweigh the positives. All right, now the variation on a theme we have to consider next is assuming the Commonwealth had been under a duty to afford procedural fairness, i.e., contrary to what we just concluded, would Makepeace's application for judicial review be likely to succeed? Okay, if we're considering that, what we're doing is we're considering judicial review grounds and not merits review such as by the AAT, because the very existence of the certificate is to actually preclude merits review. So what we've got is on the facts, so let's look at our facts. We could probably infer from the facts we have given that Makepeace was not warned of the possibility that a certificate might issue in the first place. And the second thing is, if you look at the second ground for the certificate, it seems to be based on matters that relate to Makepeace as an organisation, and also it didn't have any opportunity to comment on the findings that the attorney seems to have made in relation to Makepeace. All right, so the first argument then is, does Makepeace need to be told about the possibility that the attorney might issue the certificate? It's sort of like a bit of regression analysis. We keep challenging the decision to make a decision to make a decision, if you know what I mean. All right, there is a case called, I don't know quite sure how to pronounce it, but it's Haucher, Haucher, against the Minister for Immigration. It's a 1990 decision, 169 CLR 640. Now, in that case, the High Court quashed a decision adverse to an applicant on the grounds that the applicant hadn't realised that the Minister for Immigration might depart from a policy the Minister had, but hadn't been given an opportunity to address the question whether the Minister should do so. So in other words, there's some legal basis for saying that certainly as an interested party, because the certificate is issued against Makepeace, it should probably have been warned by the attorney that the attorney was going to give a no permission decision. And so the thinking then is that it does in fact promote judicial review, because there's a suggestion that the possibility of a negative decision should be flagged to an interested applicant, someone who's got sufficient interest or standing. Now, you always need to look at your decision process, because there's another case, just an opposite case, called South Australia and O'Shea. And sometimes if you can break a decision down into two steps, you might have a preliminary decision stage and a final decision stage. It's only if the preliminary decision stage really requires an interested party to be notified about something, that it has a right to be told about a possible adverse matter. And often the way governments do things these days is they break decisions down into preliminary stages and final stages. And it's only really at the final stage that applicants get a chance to be properly heard. At the preliminary stage, often the case is applicants don't have a right to be heard or a right to be consulted. So you just need to keep that in mind. Sometimes decisions are really quite different. Okay, so what we've got is looking at the question of really the second question, that is looking at the motives that are imputed to Makepeace. Now, do those motives that the attorney imputes to Makepeace provide a ground to actually set aside or challenge that decision? And now let's assume, for the sake of argument, that the attorney's characterisation of Makepeace motives is substantially correct. So, if they're substantially correct, then there may not be any proper basis on a factual basis to actually even proceed with a challenge to Makepeace's grievance about the way that the Commonwealth has characterised it, because on that assumption I'm making, that it's substantially correct, Makepeace can really have no beef with it, because that is in fact its motive for wanting the book to be imported. So on that alternative scenario, it probably doesn't avail Makepeace all that much, even if the motive is substantially correct. On the other hand, if the motive is completely, and let's change the facts a bit, completely factually inaccurate, then let's pretend it wasn't Makepeace's motive at all. If it's not the case, that is, the description or characterisation is so far from the truth, then as a matter of procedural fairness, Makepeace should, on the authority of Kiowa and West, and also the MIA decision MIAH in 2001, then if those facts are so completely wrong, there is a ground for judicial review based on denial of procedural fairness, because the attorney would have made a decision based on completely incorrect facts, and that would have meant, legally speaking, that Makepeace had no opportunity to contradict those facts by argument or submission. So therefore, in that sense, there could be seen to be a denial of procedural fairness to actually issue the certificate in the first place. So, but that's the kind of thing you don't discover until later on. So, yep.
What if on judicial review it was found that ground 2 was wrong?
Sorry, what was wrong? Yep.
You say ground 2 was wrong, but ground 1 was sufficient to support the Attorney General's view.
Yep.
Could the Attorney General's refusal still stand?
Well, it doesn't. If the first ground is that, if the outcome of the first ground for the second decision is that the attorney should have warned Makepeace that he or she were considering issuing the certificate, then that's enough to get the decision quashed. So you only have to succeed on one ground of judicial review to successfully overturn that decision.
Okay, so if let's say that decision was overturned.
Yep.
Where to from there? Okay,
that's always a good question. All right, it comes down to what, in a sense, it depends what the decision is as to what the remedies is. And basically, the mantra to keep in mind is you mould the remedies to suit the facts. And we say that across a lot of areas of law, but it's no less true in administrative law. So let's just recap the remedies. Mandamus is issues to make somebody do something, all right, to make a decision. So if somebody's sitting on their hands and not making a decision after an unreasonable length of time, you consider mandamus. Prohibition takes place when you want to stop a decision maker from exceeding their powers. So in other words, a decision maker might want to do something they're not legally authorised to do. Certiorari is to quash a decision, and that is basically to kill off something that has been made, and that's probably what would happen here. If on the second variation of the facts they were under a duty to accord procedural fairness but didn't do so, then the decision to issue the conclusive certificate would then itself be quashed, and the attorney would be required to remake the decision according to law. That's what the court order would actually stipulate. So generally speaking, you would use certiorari to scrap decisions you don't like.
Okay, but if the attorney was obliged to remake the decision...
Yes, according to law, yep.
Let's assume that the attorney has the right to exclude it from AAT review.
Yes.
And then have responsibility for permission or refusal.
Yep.
So, and then on that basis, he or she decides to refuse permission for the book.
Yep.
And just removes ground 2 and just says, I refuse permission on the basis of the book will severely impair the quality of our relations.
Yep.
And has the evidence back that up.
Yep.
Then you're back to where you were, aren't you?
Yes, that's exactly right. Yep. The all things being equal on that variation, the decision would stand and it wouldn't be amenable to judicial review.
Yeah, because you remove the second one, which was the one that you were using as your grounds for judicial review, weren't you? Really?
Yeah, that's right, yeah.
All right, yeah.
Okay. Any other questions about problem 14? From anyone else?
No, but just a general one there.
Yep.
Getting a win doesn't always mean you're going to get...
Sorry, Terry, start that question again. It just was a bit unclear.
Oh, sorry.
Yeah.
Getting a win doesn't necessarily mean you're going to get any different outcome, does it?
No, that's right. You can win the battle but lose the war, as the saying goes. Generally speaking, if an administrative decision is successfully challenged, sometimes what courts order is that a decision is remitted to another decision maker so that you have a fresh set of eyes on it. And that often happens in the AAT. So if an AAT appeal to the federal court succeeds on a question of law, what often the federal court judges will do is order that the decision be remitted to the AAT for reconsideration, and they'll often say quite categorically to be decided by a differently constituted tribunal. In other words, not the same decision maker who screwed up. So that's how, practically speaking, you try and get around the problem that a second decision maker might make the same decision all over again. But it's not often that you get second, decision maker stuffs up twice, because in reality what happens is if a decision is overturned on an appeal, whether judicial review or otherwise, the government lawyers would be poring over the decision. They'll then give the department advice about what the judgment means and how a particular decision maker, whoever it might be, is what they're required to do in order to make the decision according to law. So you will in fact get a lot of sort of buttressing and scaffolding taking place when a decision is remitted for reconsideration according to law.
Mm-hmm.
Okay. All right, now let's move on to problem 15, which is a variation on our wonderful Makepeace situation. And what we've got is, again, we're exhorted to have a look at it. Makepeace applies for permission to import. It's been considered by an authorised person. That authorised person wants to get it, we're told, is inclined to grant permission, but wants the Australian Securities Service to investigate the bona fides of Makepeace. And we're asked, they want to apply for a declaration that the authorised person is required to consult Makepeace before seeking information from the ASS, the security service. So, first question is, would it be successful? And secondly, are there circumstances in which, following the ASS report, the authorised person would not be required to afford some kind of further hearing to Makepeace before making a final decision? So let's break it down. Let's go to that first scenario. Again, they want to know, Makepeace wants to know, should it really make that application for a declaration that a person is required to consult Makepeace before it gets information from the security service? Now, before we even get into all the legal mumbo-jumbo, what we need to get our heads around is that certainly in the modern world, you would certainly expect security services to be...
Why would you ask for something like that, Simon? Sorry.
A declaration, yeah. Okay. Yeah. Okay, a declaration. All right, let's... a declaration...
That might make more sense then.
Yeah, okay, yes. All right. What a declaration is it's a statement by a court on a particular point of law, whether or not something proposed or done is in fact lawful. So now that might seem a pretty weak sort of remedy, but it's actually quite useful. Particularly you actually see more of them in administrative law than you do in other areas of law. You can get declarations and disputes about contracts and stuff like that, and they're quite useful, but they're even better in administrative law, because if a court issues a declaration saying that, for example, the attorney has acted unlawfully in getting a report from the ASS, then what that signals is, as a matter of administrative practice, that it tells you what a decision maker should or shouldn't do in the future. So it can be quite good. Just be aware, though, that declarations are not coercive. That is, they can't make the decision maker do it. But if you think about it, not many decision makers would actually thumb their nose at a court.
So in this case, why would you ask for a declaration?
And again, that's a good question. The reason you would ask for it is that the facts say to us, Makepeace wants to apply for a declaration that the authorised person is required to consult Makepeace before seeking information from ASS. The reason for the declaration is it lets everybody know on a proper legal basis how the authorised person should proceed in discharging his or her legal duties. So it basically signals how should people behave. So that's the utility of a declaration. Does that answer your question?
Yeah, I think so.
Yeah. Just think of it. Yeah, it's not coercive, but it tells people how they should behave. And if you've got a government department on the receiving end, it doesn't take a great deal of imagination to realise that most government departments will obey the law, because that's what they're set up to do. So if you get a declaration about this matter, then what that will signal is that what it is the authorised person should do in order to discharge his or her legal duties. And there's a moral or psychological edge to it. Go on.
How's that different from, a little bit confused, on the other ones,
yep.
Some of the other examples we've done last week and that,
yep.
was that, some of their appeals was because they got information and they never told them or never got the
yep.
information or
yep.
never followed down.
Yep.
That's a difference.
Okay. It's just, even in those other cases...
Why do they not...
Well, actually, in those yep. cases, you probably can seek a declaration that somebody has yep. breached the... and often when I've drafted stuff for court in these types of cases, you do seek a declaration that in making decision X, the administrator has breached the rules of natural justice. You might actually ask for that declaration, but you also want a further remedy, quashing the decision made so that it's of no effect whatsoever. So a declaration... to anticipate your question, you can ask for the declaration as well as for the other remedies you want as well.
So would you ask for a declaration where, is there a reason why you'd ask for it more? Is there a reason because they think that they won't tell them what the ASS says? Or
Possibly, yes. In reality, you want, you know, people want to know where they stand legally. So a declaration helps you do that. It's generally speaking not the only remedy you seek. I know our problem's a bit sanitised, and we're asked to basically advise, would Makepeace be successful in getting a declaration alone? But in reality, you'd probably couple it with another remedy.
okay.
Just on that declaration, Simon.
Yep.
They want to apply for a declaration that the authorised person is required to consult Makepeace before seeking information.
Yep.
That could be just as simple as saying we're approaching the ASS for further information, couldn't it?
Yes,
It doesn't say anything.
That's right. And remember, a lot of this stuff is, particularly from a legal angle, we're concerned with process, not outcomes.
Yeah.
And a lot of it, if you think of the distinction between process and outcomes, it actually helps you understand administrative law a lot better. Admin law is obsessed to the point of being anally obsessed about process. That is, how have people gone about making decisions? Remember, merits review is AAT, QCAT, all those sort of bodies. They get a chance to say what is the correct or preferable decision. Courts are much more limited. They're tied to legalities only. How should a decision maker behave? That's a question about process. If it's a question about process, that therefore means your remedies are a bit more limited. And coming back to the question about a declaration, even if the declaration is made, we might ask, what is its use? The answer is, it tells people how they should behave.
Okay. That makes more sense.
Yeah. Yeah, if you think of it in those terms, if it tells us how to suck eggs, that's exactly what it is. You know, it's telling us how we need to behave. All right, let's look at the at whether or not we think Makepeace would be entitled to the declaration. Now, again, remember my mantra, you always need to characterise or accurately describe what decision are you unhappy with. And the question here is the authorised person required to consult Makepeace before getting an ASS report? So if there is a duty, if somebody is required to do something in the law of, in the language of the law, that's a question of an obligation or a duty. And so the question then is there a duty to consult? And basically, the law isn't really all that strongly in favour of a duty to consult. And basically, you have to generally tie it into procedural fairness. Now, if we can tie in procedural fairness, then you've got a stronger basis for saying that there is a duty to consult. Look at T.O.'s case. And in that case, that's TEOH. And look at Justice McHugh's decision. And he kind of says this. He says, I think the rational development of this branch of the law requires acceptance of the view that the rules of procedural fairness are presumptively applicable to administrative decisions made by public tribunals and officers. In other words, the starting point or premise is that procedural fairness does apply. And a few judges picked up on that later in the 2003 decision in LAM, that's the LAM case. And so if we start with those ideas, what we've got is at least a presumption that an authorised person is required to act procedurally fairly in making decisions. Now, the other thing to remember is you have to ask yourself, is this a final decision or is it a preliminary decision along the way? And what do our facts suggest about that?
Would it be that it's just one of a decision along the way because they just want them to make a declaration before they make the decision?
Yeah, almost. There's one slight variation I'd say to what you were close. I'd put it this way. If we, it's not reviewed by the TMO in the third test or anything like that. Now, what it is this: we've got the decision to get an ASS report is a step in a chain of decisions about whether or not to allow the importation. So, if you look at it in really crude reductionist terms, the decision to get an ASS report doesn't go to the ultimate decision to import the book. It's a decision along the way whether or not the book should be the subject of an import clearance. So if we look at the duty to consult, both Tio's case and Lamb's case, the judges in those cases were saying there is definitely a duty to consult when it comes to what they call final and operative decisions. And so that's why we need to keep that distinction in mind between decisions along the way as distinct from final decisions. And my view, for what it is worth, is that...
Probably more than ours.
Oh, no, don't go there. Yeah, my feeling, I can sense it in my waters, that if I was the judge making this decision on this, that it's not a final and operative decision, and Makepeace doesn't lose anything by waiting till a final decision is about to be made. So if, for example, I'm the unreasonable judge and I say, no, to Makepeace, I'm going to hose you out, you're not going to get your declaration about the duty to consult. All is not lost for Makepeace, because before the final decision is made to import or refuse importation, it's at that point of time that Makepeace should be consulted. That often the real problem in the modern world is, will that ASS report be given to Makepeace? And we've seen some of those decisions based on passport cancellation decisions with people wanting to go off and fight in the Syrian war from Australia. There's been quite a few of those decisions made. About 20 passports from Arab Australians have been cancelled because there was a suspicion that some of these people were going to go abroad to actually fight, either for or against Assad over in Syria. And there's a law in Australia that actually stops Australian citizens fighting in foreign wars. So whether we're not debating the rights or wrongs of the Syrian uprising or rebellion. What we're doing is we are looking at the question. My analogy is those sort of decisions are being made. So we're seeing even in the federal courts these days decisions about whether or not ASIO reports on particular people have to be given, whether to a full copy have to be given to the applicants who are challenging those decisions, or is it only some kind of sanitized, stripped down version that doesn't have national security sensitive material in it? So it's a pretty pertinent question for the modern world.
So is it really a decision, or is it just part of the evidence gathering along the way?
Well, a decision to seek a report is itself a decision. You have to ask what is its purpose, which is really where you're going. And the purpose is to actually gather information in order to make a decision. So that comes back to that distinction between final or operative decisions and decisions made along the way that don't substantively determine rights or interests. So whichever way you cut the mustard, I think the decision to consult ASS isn't in and of itself a decision that's really going to be amenable to any kind of judicial review on the basis of a duty to consult. Certainly would be for a final decision. That's easy to see.
I just sort of see it more as more of a gathering of evidence rather than a decision of its own right. I mean,
well, it can be both. I mean, some things have multiple characterizations. It might be gathering evidence along. It clearly is. That's its teleology or purpose, is to gather evidence. But at the same time, it's a decision. It is a decision along the way. It might be a decision. It's also a conduct within the ADJRA, I think section 6 or 7 or whatever it is, the provision that talks about conduct. Can be conduct, for example, under section 6 of the ADJRA. But the question then is there a duty to accord natural justice to our friends at Makepeace? And I think because the courts have adopted this idea of natural justice is required for final and operative decisions, but evidence gathering, interim decisions, all those sort of things don't really cut the mustard for getting over the line for judicial review on any ground about natural justice. All right, so let's look at the the second variant. So in answer to the first one, rather, before we move away from that, would Makepeace be successful? In my humble opinion, no. The the second variation is this: are there circumstances in which, following the ASS report, the authorised person would not be required to afford some kind of further hearing prior to making a final decision? Okay, what are your thoughts?
I would have thought that you'd have to forward, show, or at least give them a chance to reply to what information you have. If
Yeah.
choosing to not grant what they want. Because
Yeah.
those cases we read, especially those immigration cases,
Yep.
they all, one thing I noticed was just because the other side wasn't given, the information to have the chance to respond, basically.
Yeah, it's this idea. I mean, it's fairly ingrained in as a matter of justice, even before we get into admin law cases, is if you're going to be adversely affected by a decision, you need to be told enough about it and why it was reached so that you can challenge it. Sort of goes against the grain to think secret information can be used to knock me out.
Is that because they could get some information, but it doesn't necessarily mean it's correct? So you could show evidence that it's not correct, so it should be taken into account?
Yeah, a bit like the previous problem where we can tweak the facts a bit and show that, there were the imputations to Makepeace's motives might be just completely wrong. Might have been based on a completely wrong piece of evidence so that the no evidence rule applies or, irrelevant considerations apply. So that's the reason why all those other grounds for judicial review sort of come in on the margins and say that, well, that's why there is a duty to consult and or disclose adverse information. It happens an awful lot in migration cases.
Yeah, that's why I read a lot of it.
Yeah.
Those
it's things like character assessments. ASIO doesn't do they do in all this terrorist law stuff we have nowadays, but in the old days it used to be based on character assessments. And there are, person's character can be a reason for getting, for example, citizenship. I've got a case I'm about to take on where it's not a character case, it's a different type of case, but I know from my experience in migration cases that, somebody's character, you might have an informant who's telling absolutely outrageous lies about someone and that they're being acted on by, the Department of Immigration and making decisions. So that's why it's important to have the opportunity to be heard on natural justice grounds or procedural fairness grounds when it comes to those sort of adverse matters.
Is there any case, like it says here, other circumstances would not be required to forward some kind of further hearing? Is there any situation going away from Makepeace?
Yeah.
But is there any reason why people don't get that? Is there any certain situation why you don't
get there is. Actually, under the AAT Act, and I think we, the course of the lectures take us there this week and next week. The AAT Act actually has some provisions in it under which ASIO does security assessments on people, and then if ASIO makes an adverse security assessment on someone, then there's always a question as to how much of that gets disclosed. And there's a carve-out, as you would expect in the modern world, for national security stuff. So sometimes national security assessments are made, or assessments are made that have heavy national security grounds, and lo and behold, the applicant might never know what those national security grounds were. And that's a balancing exercise. Does the state have to disclose all its secret knowledge on national security grounds as distinct, so that there's collective justice for everyone else and collective security as distinct from giving an individual who's ticked off about a decision information that might go to leaking national security matters? So it's one of the big questions that's being bandied around in our terrorism world.
Okay.
Simon, on that second question,
Yep.
are we assuming that the ASS report has changed the authorised person's mind? Because he was inclined to grant it, got the report, and the Didison report, and said it's all good to go. There's no real need to confer another hearing.
That's right. Yeah. If the we don't know the contents of the report, again, the facts are deliberately vague. If the report is supportive, then there is no need for a further hearing. It's only if, of course, the report has some negative material that a decision maker, the authorised person, would have to consider to what extent do I need to comply with procedural fairness and disclose, or how much of this report must I disclose in order to afford or satisfy a threshold for procedural fairness. And these days in our national, in our security conscious world, I have a sense in my waters that the balance would tilt against the applicant and in favour of the state. And we're seeing that in some of the decisions that have come down in this area on, administrative stuff.
Is that more a further hearing before the final decision, or is it that the outcome of that ASS report should be included in the reasons for the decision?
It's the second as informing the first. So in other words, if we talk about a further hearing, that comes back to a question about what does the content of natural justice require? And normally, it's the opportunity to be heard. So as much of the report as is negative needs to be disclosed in some way. The supplementary question is does natural justice require a full-blown hearing, administrative hearing, quote unquote? And the answer would probably be no, as long as there's an opportunity to be presented with the adverse material and have the opportunity to contradict it. That's the minimum content of natural justice.
Before making the final decision.
Yeah, that's right. So the question would be, in practical terms, how much of the adverse ASS report would need to be disclosed? The answer is as much as enables Makepeace to understand the factors that a decision maker will be called on to consider in making a yes or no decision on the importation. So it's difficult to decide that in the abstract, given that we don't know what the report says. In a sense, we're being invited to consider, it swings both ways.
Yeah, I'm just trying to get my head around this with this bit of a process. So let's say the decision maker is inclined to grant the permission.
Yep.
Gets the report, and the report changes their mind.
Yes.
Is it at that point that they should say to Makepeace, look, this report is adverse, we need to discuss this?
Yes.
Or should they just do that to the final decision and say, as a result of the ASS report, we are declining the permission?
Well, your second, what you've just said then, the second scenario is in fact too late. It's at the point of getting the adverse ASS report that the decision maker should think, oh, this report is quite adverse. It could actually change my initially favourable decision that I'm thinking of making. It's at that point of time, before they act on the ASS report and make a negative finding or decision, that they should go to the applicant and say, we have had some bad news. This is what it is. What do you want to say about it?
Yeah.
If you were to get that report and then you took it to the Makepeace and you still refused it. Is that more in the favour of the minister or the person making decision? Like, does that give the Makepeace less grounds to appeal because they were given that, and even if they put in the reasons and they still refuse, where straight out don't give them a chance?
Yes. That's a way of bulletproofing a government decision. So you actually give the applicant the adverse news, the report or whatever it is, and as long as there's proper and real consideration given to the report, and for that matter, a real proper opportunity for Makepeace to make submissions to change the decision maker's mind, as long as those things are real and not illusory, then one would expect that a negative decision would stand up to judicial review.
Okay.
Well, that's really affording procedural fairness, isn't it?
Exactly, yeah. Remember, courts don't dictate outcomes. The courts are concerned about process. What process should be followed? It's not merits. The import or to refuse importation decision, the courts don't generally give a rip about, but they are really concerned about how we got to that decision. So, in a sense, if you go back to that Section 580 JRA and use that as a bit of a checklist, it's telling decision makers. I mean, if you look at it from a sort of like a helicopter perspective, it's actually saying to decision makers, we're going to structure how your decisions are made. That's what Parliament has said in Section 5, and don't forget, most of these Section 5 grounds came out of the antecedent common law. So between the courts and Parliament, they're saying to the executive, this is how we want you to make decisions. So it's about process, not outcomes. Or it's about process, not merits. And that's why, in a sense, administrative law is a bit limited, because merits review means a decision maker like the AAT can stand in the shoes of the original decision maker and say, taking into account all the original information plus more, I can make the correct or preferable decision, which is what I always used to say when I was writing AAT decisions. I say, what is the correct or preferable decision I ought to make? Answer, it's this because, and I'd give reasons. All right, any other questions about anything we've covered tonight?
Probably heaps, but I'll think of them after we...
Yeah. Now, I was just thinking, we can always send an email or something. I was thinking probably for the last week in revision, I'm thinking of putting on one of these Zoom tutorials where people can just fire questions at will, and I can sort of do my best to bat the balls that are bowled at me. Would that be of any assistance to the student populace?
Is that like for the last one before exam time?
Yeah.
Oh, good, because I was going to say, I'm not at exam yet. I've got to get past assignment.
Yeah, no, I realise that there's, we've got to walk before we can run. That is true.
I know, but I'm struggling with the assignment, let alone the exam.
No, you'll be right. You'll get there.
It's doable.
It's doable. Oh, it is. It's a big topic, but you just have to cut it down into bite-sized pieces and then just work your way through it. It's probably one of the largest questions in administrative law, which is why I said it. It's something you'll always think about whenever you have to do admin law.
I'll think about it when I have to do it. That's right, at work. I'll think about you and think, Simon.
Yes. Yeah. Okay. All right. Yep.
That last week would be great.
Sorry, say again?
That session in the last week would be great.
Yeah, no, I will put it on. So I'll do that. Okay. All right. Well, thank you.
Are you planning to do a Zoom next week? Or
yes. Yeah. All things going well. Monday night Zoom. So I'll try and let people know as far ahead as I can. We've still got these stupid technical issues with the video, but we'll see how that goes. I'm going to hook up with Stephen Colbrand and try and sort that out in the next day or two. I thought we had nailed it down, but there's some problem with it. We think it's at the Zoom end. I'm sorry, that was very muffled, Terry.
Sorry, the video doesn't take too much away from it.
No, hopefully not. Look, that's why we're still audio recording them, or if I did them as a podcast or whatever, it wouldn't make any difference. But Well, no, I don't think we get this sort of interactive, collaborative thing if it was a podcast. I could be wrong.
No, I like the interaction. That's why
Yeah.
I try to be home so I can
Yeah.
do this. So I
Yeah.
can,
Okay.
because reading a book, reading hundreds of pages, and I find looking at the thing doesn't necessarily sink in.
No, it's a
Talking.
bit, to be honest, it's a bit sterile.
Yeah, and I sort of get to the end of it and just, I went to Brisbane last week. I read it on the plane down.
Okay.
I read it down there, and I had
Yep.
training down there, and I just read it all, and I'm like, this is just going in and out. And
Oh, yeah.
so these really help me look back at what I've read and try to put it in perspective.
Sure. Okay, well, that's good. Okay, then.
Doesn't mean I get it.
No, I can understand. Well, in a sense, you're tackling it for the first time, whereas I've lived with administrative law for a long, long time. You know, I don't do a case on it every day, but I do a good few every year, and then, you know, dabble in it even more intensively from time to time. So, you know, I've got the luxury of having 20 plus years on this, on almost 25 years as a lawyer. So,
and what I deal with at work isn't really the administrative. Like, I've done some other subjects, and my work's helped me. I've got good grades.
Yeah.
But this one I don't really do. The judges don't sort of do admin law. So
no, it's a bit left field. And which court are you in, Robin?
I'm Bowen, but I'm magistrate and district court.
Yeah. Okay. Yeah. See, the DISO wouldn't get a lot of this sort of stuff.
No, it doesn't.
From what I understand. Well, certainly judicial review stuff goes purely to the Supreme. And then, you know, other sort of common law admin stuff wouldn't come up often in the district court. It can come up in sort of on the margins of appeals from the Mags Court to the district court. Some of the principles that we're talking about here can be a reason why an appeal might succeed, or those sort of things from the Maggies to the district. But it's not sort of bread and butter work that a district court judge would necessarily be doing day in and day out.
It's not something I see a lot of, or I think many people see a lot of. I'd see more against appeals against convictions or penalties or stuff like that.
Yeah. I mean, some of the thinking that you even get in this stuff sort of cross-pollinates with it, but it's not, you know, it's not directly applicable.
No, which is what you were saying, like a bit like, you know, the judges make a decision and then obviously someone doesn't agree with how they decipher the facts or how they read the law to be, which is what you're sort of saying, isn't it? Or in a roundabout way.
Yep, that's right.
That's okay. I'll get it one day. I'm trying.
No, you will.
Getting there.
It's got its, once you work out the internal logic of admin law, and there's a few basic principles that I keep trying to drive home, then once you work those
big words.
Yeah, sometimes.
Those Latin words.
Yes and no. They're just tags. I mean, you just deconstruct those. But once you work out that really admin law is driven by a few very basic propositions, once you've got those and you understand them a bit, the subject becomes quite a bit easier.
Because those books you read, like I've got the things that I print out that you have on there, and they're massive. And then I'll read the books, or I sort of, when I'm lying in bed, try to read the books, but the writing's so small and it's so much that I can read pages and pages and look back and think those questions at the start of the cases, I can get to the end and think, I didn't get that.
In terms of the book, I mean, I'm obviously reading and rereading Kane and MacDonald. That's actually quite good for getting a bit of a helicopter approach, which I
Is
also
that a
like.
different one? That must have been one on our list. That's that
Yeah,
other
it's on the list. It's one of the prescribed works, Principles of Admin Law by Kane and MacDonald.
Is that the one there's two of?
There's one. It's got a companion that's got the Cases and Materials book that goes alongside it. So, but the text rather than the Cases and Material book isn't bad. I mean, sometimes my eyes glaze over it a bit as I'm reading it, but it's actually got quite some good sort of what I call helicopter stuff, which sort of they try and sit over it all and try and make some sense of it, and then you get immersed or thrown into the murky detail. But I thought it's one of the better works written in the last few years, whereas other texts.
It's good to read the case. It is good to read cases. They just ask those questions at the start. This is my perspective. It is good to read cases, but sometimes I'll get to the end and go, I just really didn't get that. And other ones I can get it, and that's where I struggle more. Like I can read and read, but just don't get it.
Yeah. Unfortunately, well, it's because of our common law method, but actually the way to understand, to get your head across any course, textbooks are fine, but you learn how it works in the cases. And when I was a law student, I was doing my degree part-time, and I just used to read. We'd have a case list in every course, and I would go and get all the cases photocopied, and I would read them, and just, that's how you learn common law method. That's how you get your head across all this stuff.
Yeah, well, that's the one of the case book is I enjoy reading the case book better than I enjoy reading the other one, the legal regulation of government. Like, it's intense.
Yeah.
Where the cases at least give you some sort of inkling of what you've just read.
Yep, sure.
But it's just that judges speak that language.
Yeah.
That isn't simple.
No, but you know, it's all a question of getting across the jargon, and you know, it all becomes a bit clearer as you work your way through your degree, and you understand more and more, and you see how the dots are joined up.
I hope so. This is only the end of my first year.
I see. If you end of first year, yeah. See, by the time you get to fourth year or whatever, I don't know how many years. How many is the course?
4. If I do the 6 subjects a year, I can do.
Oh yeah, the 24. Yeah, look. By the time you get to say beginning of year 4, a lot of the questions you have now you'll have answered well along the way. So it gets better.
I've asked the judges that, and I asked my magistrate, and I asked some of the other lawyers, and they're going, it gets easier as you get along.
It does.
The first year is quite hard, and you've got a routine and get in. After that, some things will sit into place. Yeah.
And some subjects are easier than others.
Well, I did criminal law, and I got like HDs and Ds for that because it's just what I do every day.
Oh yeah, yeah. See, simple, I don't do much in that space, so I struggle.
Yeah. How did you go with that guy that you were going to go to court for, the public nuisance man?
Yeah, we've got a trial set down in, I think, end of Feb, and we had a magistrate who I won't name, who was trying to reimpose bail conditions I got lifted. So that was on a time I couldn't appear for the guy on a mention. So anyway, this magistrate was trying to undo all my good work from the previous hearing. Anyway, so we've got a trial, so I'll happily turn up and bat that one through.
You'll have to tell me how you go.
Yeah, I will. I'll phone you and have a separate conversation.
Yes, you'll have to.
All right.
But anyway, okay.
Okay. Better love you and leave you guys. And
yeah, we will talk next Monday.
Yeah. So expect Monday 6 p.m. And
if you weren't to do it, what time would you tell us that you're not doing it? Because
look, no, I would let you know early in the day. Yeah.
Yeah. Okay.
I am expecting having to do a very urgent, unusual interlocutory application, but I'm hoping to get that done this week. But yeah, look, I'd be 90% sure at the moment that we'll be on next Monday night.
So even though next week's an actual week off, it's a
look, I mean, because I'm doing I'm still trying to catch up on some of these things. I'm still inclined just to keep doing it unless people don't want to.
No, I want to keep going. This is great for me.
Yeah, that's
and then the following Monday. Yes, hopefully so.
Now, so there's next Monday, and then after that is that the Monday just before Christmas, is it?
No, next Monday's the Monday just before Christmas.
Okay, all right.
And then the following Monday, I'm on 2 weeks leave. The courthouse is closed for 2 weeks.
Okay.
So I get 2 weeks leave, which is great.
Right.
I think the following Monday after that is the 30th of December, which is actually a working day.
Yeah.
Not for me.
Yeah. Okay.
And you wouldn't be either because the courts would be closed, wouldn't they?
Yes, they are. Yeah, no, unless you've got a really urgent matter that you have to go up. They're sending us all away. All right. Okay. Nice interacting with you all.
Yes.
And
us too.
Yeah, and we'll confer next week.
Thank you.
Okay. Enjoy the rest of your night. Okay.
Thank you.
Bye-bye. Bye-bye.